my Lords, I rise to speak to several amendments that I've signed in this group, but they're all very good. I wanted to mention non-disclosure agreements first, because really they can be exceptionally toxic and corrosive, because they can be used to cover up a wrongdoing by an employer. So it's a very dangerous game. They're not simply a contractual arrangement between two willing parties, because the employer's wrongdoing could affect other employees as well. So it's much, much wider, and it's not just the employment who is party to the agreement. So I very much support 101 and 98, and I hope that, as the noble lady says, we could find a common agreement on it. Now, the noble Baroness Lady Kramer did a very thorough skate through all of these, so I'll only mention 3 of the amendments that I have signed. I feel very strongly about this because whistleblowers save public money and expose bad practice, and they should be celebrated, and yet they're actually treated as traitors by professions, by public services, by corporations. And Amendment 147 would turn that around by having a duty to investigate placed on those organisations. My own experience of a whistleblower was when a police officer came forward and told me about the domestic extremist database which I was on, but thousands of other people were on that domestic extremist database as well. And they were journalists, there were MPs like Caroline Lucas, there were local councillors, there were all sorts of people. And the 2 things we all had in common was that none of us had committed a criminal act of any kind, and the other thing was that we had all said things that challenged the status quo, and that was enough to get us onto that domestic extremist database. Now, I cannot imagine how much that cost, because the police were tracking all of us, keeping details of what we were doing. When I spoke in Trafalgar Square, I went on a cycle ride. All of these things were kept about me on that database. What an absolute waste of police time, taxpayer money, and absolutely pointless spying. I mean, I put everything out on social media. They could have just followed me on social media. And of course, ex-spy cop Peter Francis blew the whistle on how the Special Demonstration Squad was spying on Lady Lawrence, our own Lady Lawrence here, when she and her husband were campaigning to get justice for their dead son. Whistleblowers need the reassurance that they are taken seriously, and giving the company or organisation they work for a duty to investigate would actually provide that. It would also combine with the government's new duty of candour to help change the culture of many organisations. Now, I know the Minister is keen to speed up the progress of this bill, and I don't think that this side of the chamber is helping in any way. But these current laws are outdated, they are inadequate. So rather than spending ages examining the whole subject, it would be quite good to just adopt this particular very modest amendment 147. Now, Amendment 126 would ensure that those whistleblowers left out by the existing framework finally receive legal protection, because the last 25 years has seen a massive rise in self-employment and subcontracting. There are now many more people in workplaces who may spot wrongdoing or risks that have no legal remedy if they blow the whistle. The Post Office Horizon scandal saw hundreds of sub-postmasters wrongly accused and sometimes imprisoned for fraud and false accounting. Lots of people knew that the Horizon system was going wrong from very early on, but the sub-postmasters didn't have the legal protection to blow the whistle. And this amendment also grants whistleblowers strong protection from blacklisting when applying for work. At present, only job applicants in the NHS are protected from discrimination as whistleblowers. We encourage those NHS workers to speak up because it saves lives. But we allowed workers in the building industry to be blacklisted for raising health and safety concerns which would stop deaths on dangerous sites. Some of those in the building trade had to emigrate in order to find a job. This amendment would have helped protect them. And I understand the government saying that they need to consult first, but a lot of that legwork was actually carried out by the previous government, and it seems ridiculous not to just publish that whistleblower framework immediately so that we can make change happen faster. Now, Amendment 281 seeks to make express provision for court discretion to void non-disclosure clauses in employment contracts. The growth of the use of non-disclosure agreements is a big concern, and recent allegations that gagging clauses contributed to the cover-up of decades of sexual abuse by former Harrods owner Mohammed Al Fayed have once again led to calls to ban them here in the UK. Last September, the BBC revealed that 5 women claimed the billionaire Mohammed Al Fayed raped them while they were working at Harrods department store. And we've already heard, as others were, she was forced into signing an NDA to prevent her speaking out. And these agreements can, I think, be, as I described them earlier, they can be corrosive, they can be toxic, and they could be immensely damaging to the individuals who actually sign them and then regret signing them afterwards. This is a really important group, and I hope the Minister perhaps can meet with some of us and actually discuss a way forward to incorporate some of the sense of these amendments into the bill.